Welcome, everybody. My name is Marty Mascari. I am a contractor with the North Central Texas Council of Governments under the Area Agency on Aging and the Aging and Disability Resource Center, or ADRC. We serve the greater Dallas-Fort Worth area. We actually serve 14 counties, to be more specific, around Dallas and Tarrant counties. Tarrant County would be Fort Worth, Texas, but we do these webinars, and we love for anybody to participate. And I know not only do we get people across the state, but we get people from across the country and even outside of the country usually, and we're glad to have everybody. So we're here with our friends at Hogue Barnett this morning to talk about law changes that might affect you. And really, part of today's goal was to have you guys bring questions that you might have about the law and law changes. And we've got a lot of time built in today to answer questions. I will ask you, if you do have questions, if you'll please put them in the Q&A and not in the chat. It's just a whole lot easier for us to access them more efficiently than to have to scroll through the chat and try to find the questions that are in there. So please put your questions in the Q&A. We'd certainly appreciate it. Rex, if we could advance to slide 1, and we'll talk about CEUs. So those of you that are joining us today that are looking for CEUs, we're providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to go through the process and get a certificate. I've had people tell me they've been able to use them for other licenses, but that's who we're set up with. And just know there's no guarantee. But like I said, I've had people that have told me they've been able to use them. I have even been contacted by jurisdictions before asking for more information about a webinar we've done so that they can determine if it meets their threshold for their CEU standards. So feel free to go through the process, get a certificate. We're also providing certificates of attendance for those of you that would just like one of those, or I know we get students on these sometimes, and they need to have those to turn in as part of their classwork. So today's webinar is worth 1.5 hour CEU credits. You must attend the entire webinar and the Q&A, and especially the Q&A today. I kind of expect that we're going to run longer on Q&A because we've left a lot of time for Q&A. But if you need to go at 11:30, that you're fine. You've fulfilled your commitment, and I understand you have other commitments because we've advertised it from 10 to 11:30. If we happen to go short, well, you're still eligible for the CEUs that the 1.5 hour CEUs. In order to get the CEUs, you must complete the Google evaluation survey. That should pop up as you close out of Zoom today. It should ask you if you would like to take a short survey. That will get you to our survey. But if you don't get that, some companies prevent those those pop-ups, I'm sorry. If you don't get that, don't worry. You'll get a follow-up email. Most likely will go out tomorrow. You'll get a follow-up email with a link to that survey for you to complete that. You'll have until the 28th to complete the survey, and give us about 4 or 5 weeks. We're a little bit even farther behind than that right now, but we are catching up some. Hopefully we'll get it back to 4 weeks is what we try to do. Sometimes it's been at 2 weeks. Sometimes it just depends on what all's going on. So I'm going to turn it over to Rex Hogue, who's the attorney and partner at Hogue Barnett. And Rex, it's all yours.
Thank you, Marty. We're going to be talking about 2025 law updates. We are in a missing presenter formation. Susan, my partner, was going to do some of this. She had an appointment at 10 o'clock, and this got put on her calendar at 9:30. So she promised to be here for the first 30 minutes, but that was before we discovered that little mishap. So I told her I will make up her part. Um, We did not have from our legislature this year any law changes that affected either the trust code or the probate code. Um, there are some changes that will have an effect. I'll talk about them in the tax law, but what I'm going to do is cover the basics quicker than I normally do. I always consider that there's three things out there that are classes of planning dragons. The first is administrative dragons, power of attorney failures, guardianship, probate, and medical documents is one of them. Another is taxes, capital gains taxes, gift, estate, and generation skipping transfer taxes. There are definitely changes in the law in that area. And then business entities that have to do with entity taxation, tax method, audit risk. And then finally, predator and creditor claims, protecting yourself and what you leave others. So these are dragons. The hardest part of this was taking pictures of these live dragons you see moving around on the screen. And I'm going to start with why powers of attorney failed. To be effective, you have to get third parties to accept the power of attorney. Power of attorney is an invitation to third parties to let someone else act on your behalf. Now, I've got several things on the screen, but I'm really only going to talk about two of these. The first is the principal is the person who signs the power of attorney, and the agent is the person they allow to act for them. Well, third parties are going to want to know, is the principal still alive, because that power of attorney dies when the principal does. How do we prove the principal is alive if they're not there? The second thing is, how do they know if the principal hasn't revoked it? It's not like you have to go file that somewhere and there's no way they can know. But in either case, if they let the agent take money out of an account, for example, and then it turns out the principal was dead or they were working with a revoked power of attorney, that institution, that third party, will have to put the money back in the account, and that isn't how they make money. So if you really understand the significance of that, you'll know why powers of attorney fail as often as they do. If the power of attorney fails, what's plan B? Well, that's determined by how assets are structured. So the first possible plan B is a guardianship. I define guardianship as the court-supervised management of assets for someone who is legally incompetent. It's necessary when a person owns assets in their own name, they become incapacitated, we need their signature to manage assets, but they're not able to legally sign, and there's no other planning that will work. Guardianship is not the problem. The problem is that person is incapacitated and they can't sign their name. Guardianship solves the problem by having a judge authorize a substitute signature. Guardianship is sometimes the only solution to the problem. The question I'll just ask you as we go through this is it the best solution to the problem? There's 12 steps to guardianship. I tell people guardianship is one of those 12-step programs that nobody really wants to be in. The minimum cost, I've heard it can be done for about $9,500. I've never seen that. Most of them cost $30,000 or more. The cheapest one I've ever seen is $17,500. I don't know of anybody who's been through a guardianship who ever wants to have anything to do with another one. The annual cost is at least $2,500 minimum, but it's usually more because there's things that you have to do every year. Seems like a constant stream of surprises for as long as the ward is alive. And guardianship is disastrous for otherwise good estate, business, and asset protection planning. So in a nutshell, guardianship leads to a lot of time. It takes months to get it in place. It's a lot of money. You're going to have at least 2 lawyers involved, a doctor, a social study. Those costs come out of the guardianship estate. And if you've got 2 lawyers and a doctor going to court, that ought to tell you it's not going to happen quick and it's not going to be cheap. It involves a lot of going to court, usually multiple hearings. The family loses complete control, and really there's a loss of dignity. Nobody really wants to have to go say mom or dad is incompetent in court and testify to that publicly. And it creates a major asset protection problem because any creditor can simply attach their claim to that guardianship. It's a lawsuit, and they can have their case heard at the guardianship course, which complicates it even more. The alternative is a trust. So on the left, you see if a person owns assets individually or 2 or more people own assets together. A house is a good example of that. One becomes incapacitated. We go to the guardianship, we go to probate for guardianship of the estate, which is very difficult, or the person, which is easier, but still not a lot of fun because it still involves saying, mom's incompetent. The alternative is a trust. You can become incapacitated with a trust, but the rules are quite different. The trustee holds legal title, and it's the trustee who's responsible, not third parties. So third parties would a lot rather deal with the trustee than an agent. Trust can have incapacity instructions. They work best when the assets are fully aligned with the trust, meaning the trust owns the assets. Now, I normally will give some examples of this, but I'll just tell you that a trust is far easier to deal with than guardianship. And it is far more reliable than a power of attorney. Now, once a person dies, everything goes into what I call the estate settlement cost funnel. Everything goes in the top of the funnel. There's 4 types of expenses that come out: administrative expenses, probate expenses, creditors or predators, taxes. If you have to file the 706, which is the estate tax return, costs are going to increase and it's going to take a lot longer. And I ask 3 questions. Which administrative rules apply? How many different rules apply? Where do you put your family in this process? The next page shows you the 6 ways that assets can pass. The first they always look for is, does it pass by right of survivorship? If so, it goes directly to an individual survivor. If it doesn't pass by right of survivorship, we ask, is there a beneficiary designation, or is there a pay on death or transfer on death designation? I call that planning by the box because there's a box on the form that says, where do you want the assets to go if something happens to you? Whatever you put in the box dictates the rules. If you put an individual's name, you're now playing by the same assets as you are with right of survivorship. The problem with those 4 ways of passing assets is you can lose control of the assets and they will blow any tax planning you may have done. If it doesn't pass by beneficiary designation, POD or TOD, we ask, is it owned by a trust? If so, it passes according to the trust terms. If it isn't owned by a trust, the only thing left, it's owned by an individual, and it goes through probate. In probate, it is controlled by the person's will or intestate succession, which is the will our state legislature has written for everyone in case they either didn't have a will or their will isn't valid. Now, if they've used a trust-based plan, we have the will pay the assets into the trust. Now, all of these get assets to beneficiaries, but they're not equal in the way they do it. So this next slide, there are 22 different ways that a person can lose control using either right of survivorship, beneficiary designations, pay on death, or transfer on death designations. And there's all kinds of fun issues to figure out, like who's going to pay funeral costs, final bills. You've got beneficiary designation that says it goes to the 3 kids, but one doesn't want to pay their share. That's a problem, and it happens. And I could spend a lot of time on this, but I'm not going to. Just be aware that those ways of passing assets have a lot of complications. Now we're going to look at the administrative rules. Now you always have to consider case law, banking regulations, the Internal Revenue Code, and the Treasury regs. Now with right of survivorship, beneficiary designation, TOD, and POD, there is one common set of rules, and it's in that big red box at the lower left. Notice that under the Internal Revenue Code, there is special bad tax rules that apply. Then in each state where you have owners, survivors, beneficiaries, or where assets are located, you've got multiple laws that could come into play. There are states of probate code, the property code, the insurance code, the family code. And the problem with that is you may have to look at Texas law and another state's law. And if you have kids in multiple states, you're going to get to deal with multiple state laws if you pass assets any of those ways. And those rules may be very inconsistent from one state to the next. If you use a trust, one law applies. The Texas trust codes, assuming it's a Texas trust, of course. Then if you go through probate, you have to go through probate in each state where you own a real property interest. And you'll deal with their probate code, the property code, and possibly other laws depending on the situation. And I tell people that when you have to go through probate because you own property, I'll use Wisconsin as an example. You've got to go through probate in Texas, and you've got to go through probate in Wisconsin. The attorneys are doing exactly the same thing, but they can't help each other. People have told me I feel like I hired 2 law firms for the price of 3. There's some truth to that. There's a fair amount of duplication of effort, but nobody can help it. Now, if you look at these 4 ways, the 4 sets of rules, if it's not obvious to you, I'll tell you, the trust has the simplest rules. It has the fewest rules. The rules are the most clear. And one thing I love about trust is it's very easy to determine what the rules are going to be. That's not the case with any of the other ways of passing assets. Now we're going to talk a little bit about probate. Probate is not the problem. The problem is a person owns assets in his or her own name. We need their signature to transfer assets, and we have not figured out how to get dead people to sign. I have no idea how they vote. We can't even get them to sign stuff. Well, probate solves that problem by having the judge authorize a substitute signature. If that sounds familiar, that's because it's the same reason we have guardianship. Frequently, probate's the only way to deal with this problem. And once again, I'll ask the question, is it the best solution? Now, I'm going to shorten what I normally talk about with probate, but we'll start with definitions. Probate technically means to prove up the will, but my experience when clients call our office and ask about probating the will, that's not really what they want to know. They want to know about the entire process. The layman's definition is the court-supervised transfer of assets for somebody who's died. So the prove up happens in one appearance at the court normally, but the transfer of assets goes on for many months. People ask us two questions: how much does it cost and how long does it take? No one who is being honest with you can answer those questions in a straightforward manner because they don't know, and I'm going to show you why. Now, one of the things we learned under the pandemic was that courts, sometimes we used to be able to get somebody to a hearing in 6 to 8 weeks. But when COVID was going on, sometimes it was taking 10 to 12 months. And that's the first part. It goes on for many months after that. This questions you really should ask is who gets paid first in probate and who controls the process. Now, under Texas law, there's really 9 people who get paid, and this is the order: funeral and last illness up to $15,000 each if the court approves. And when you see things in our law that say if the court approves, the way courts approve things is lawyers go argue it. It's not the cheapest or fastest way to do anything. Then comes the family allowance, and that is frequently thrown away because it's more complicated than it appears. Then comes the administrative costs: attorney's fees, court costs, executive fees, preserving, safekeeping, managing the estate, unpaid guardianship fees. There's a lot of stuff that falls after that, under that. Then secured claims and tax liens, unpaid child support and interest, taxes, penalties, and interest is the IRS. And we're kind of proud that we've got a lot of people in Texas in front of the IRS. Let's see, as I look out in the audience, none of you look like you've been in jail or prison, but the cost of that can be, the state can go after the estate for the cost of keeping a prisoner. And repayment of medical assistance would be like Medicaid. There is Medicaid recovery. And then other claims that are generally unsecured. And I'll just give you a hint, folks, if you or somebody you know has rental property held in your own name can create an absolute nightmare for your family, in that technically they're supposed to pay you, but you're dead. They can now only pay the estate until the estate account is all set up, and that can take months. They don't have to pay the rent, but your family still has to pay taxes, insurance, and repairs. Now, who isn't on the list? It's the family. They don't get paid until after all of these people are taken care of. Now, who controls the process? Well, sadly, it's not the attorneys and the courts. If we did, this process would, I promise, be a whole lot better. The people who control are the people who make claims. Nobody knows how many claims will be made. Nobody knows how long it will take to resolve those claims. And I've started probates. One in particular I remember, where the lady said, "Oh, yeah, we didn't have any debts." Well, she was about to learn that her husband's car that she thought he owned was in fact leased. And it was a couple of months before they notify her, "Hey, he hasn't paid his lease payment. What's going on?" Well, we had filed a probate saying that there were no debts. We had to go back and refile. It was a mess. She did not know about the debt. And by the way, the judge wouldn't let us do a regular probate because we didn't know of any debts. So that can become very complicated. Now, I've already shown you that a trust works better in case of incapacity and it works better in case of death. But we're now going to go to protecting beneficiaries. Carrie was a young lady who inherited $3 million from her parents, but she was involved in a car accident in Massachusetts. I won't tell you the whole story, But basically, 3 people were killed in the accident. She was knocked into the vehicle where the people died. And the jury, there was a huge lawsuit over that case. The jury came back with a $9.8 million judgment. They found the guy who hit Carrie 90% liable. They found Carrie 10% liable. Most people think, well, she has to pay $980,000. That's 10%. Except that's wrong. Massachusetts is what is known as a pure joint and several liability jurisdiction. That means if you're the least bit liable, you could pay for all of it. If you happen to live in California and you heard about the accident, you could pay for it. Okay, that was a joke. Now, here's what's interesting is that with Carrie, the same exact result would have happened if the assets had been passed by right of survivorship, pay on death, transfer on death, or direct beneficiary designations. A trust with the right features is the only thing that would have protected her. Compare that case to Ted, who got a little bit too much elbow exercise one night, and he failed to negotiate the bridge over the Chappaquiddick River. He was drunk, drove off into the river. Mary Jo Kopechne died. The Kopechne family could not touch the heritage trust that Ted Kennedy's family had left for him. Then in 1982, he went through a divorce with his wife, Joan. Joan couldn't touch that heritage trust either. In fact, she also found that it couldn't be counted against him in the divorce settlement. So the judge had to treat it as though Ted Kennedy was penniless, except for what he and Joan had. He remarried a lady named Vicky. After he died, Vicky found, like Jacqueline Kennedy and Ethel Kennedy before her, since her name didn't start out in life as Kennedy, the bloodline protection in that trust meant she wasn't eligible for anything. And the bloodline also would not be made ineligible for any governmental assistance programs. And that same rule applies in Texas. Then under Texas law, there's no estate tax for 300 years until after the last named beneficiary dies. And these protections can go on for generations. And I've been telling people that I'm going to retire after a couple of 100 years. I won't be around for that. Now, I've given you this as background because some of these law changes affect some of the things in here. And if you don't have at least some understanding of it, these tax law changes won't mean as much to you. So in July, Congress passed and President Trump signed the One Big Beautiful Bill Act, a law that has both the name bill and act in it was named by the Department of Redundancy Department. Those two things mean the same thing. And that must have been while the Department of Government Efficiency was asleep. It's a goofy name. We know it as ABBA, but it is a permanent law. And what that means is that it is permanent until Congress and the president change it. I'm going to talk about that in just a little bit. But what it did is it kept most of the 2017 Tax Cut and Jobs Act intact. It set the gift tax exclusion in 2026 at $19,000 per person. And in 2026, the estate tax exemption is going to be $15 million per person. Now, I hear some of you cheering, going, yay, I don't have to worry about estate tax anymore. That would be wrong. Here's why. First of all, at some point, and I heard this, I was at Wealth Council's symposium in September, and every single speaker who talked about ABBA mentioned this. someday, folks, the pendulum is going to swing back the other day. It is highly likely that the estate tax exemption is going to go down. And if you totally ignore estate tax planning, you could easily be caught after one spouse dies, finding that the surviving spouse is now under the exemption and is going to owe estate tax, and the couple will have blown the opportunity to save that estate tax. That's part of the significance of it, but there's also considerations that you need to consider. First of all, does the family have kids who live out of state? That's important for a couple of reasons. Well, really, three come to my mind. One is, what asset protection features does that state's law have for people who live there? Massachusetts and California are two states that basically don't have any. And they, for whatever reason, think that everybody ought to be able to get to the assets. The other factor you have to consider is some of those states will say, if you've got a kid who lives out of state and they are a trustee on that trust, does that state subject the trust to that state's income tax law? That can happen. There's probably about 8 states that do that. And what you really want to avoid is, you at least need to consider that in the planning. It could be that your very best person to take over lives in California. Hey, you're going to have to make a tough decision. You're going to subject it to California law. But you might also have other states, and, if all 8 of your kids live in different states that have that as a state law, that could be a problem. Another issue is firearms transfers. This is Texas, and probably only about 98% of our clients have firearms. But firearms, there's some tricky issues with transferring them, and you do have to consider what state they're going to. And I had somebody in my office this week who mentioned that they've got a beneficiary who lives in Denver, and he's the likely candidate for the firearms. Except Denver has this quirky law that he's not going to be eligible for those firearms. And that came as a surprise to my client. And it'll be a disappointment to the kid, though maybe he'll move to one of the suburbs by the time she dies. Another thing you have to consider is, what do the kids do for a living? Are they in a high-risk profession? Are they a business owner? Do they have rental properties? In other words, if they get in a car accident, for example, is it going to be with a person whose idea of retirement is winning the lawsuit lottery? And, it's a fender bender, but oh, wow, business owner, doctor, lawyer, they have money. Wow, my neck hurts. My back is killing me. You see what's happening? That happens in real life, folks. Then, what does their spouse do for a living? Perhaps your daughter's a stay-at-home mom, and that seems relatively low risk. The minor kids hardly ever sue their mom. But if the husband's a doctor, you need to consider he's in a high-risk profession. So you can't ignore where they live, what they do for a living, and what their spouses do for a living. There's some specific tools that most couples should use. I'm going to say that no more than 99% of the married couple should use an AB trust. It's not just a tax tool. It does provide some tax planning, but The more important things it does have nothing to do with taxes. The Heritage Trust. Now, these go by lots of other names. I've got some creative colleagues who have given them all kinds of names. We call it the Heritage Trust. It's that trust that protects what goes down to the kids. Then the Retirement Plan Trust, if they have qualified retirement plans. Well, there's tax laws that come into play with retirement plans, particularly inherited retirement plans. And under the 2020 Secure Act, which remains the same under ABBA, when you pass that along to the kids, they're either going to get a 10-year rule, which the retirement plan trust can provide, or they're going to get a 5-year rule, which the living trust with Heritage Trust can provide, or they're going to get it individually and lose the asset protection in all but 8 states. So those issues, you need to think about them very carefully. Now, I am going to turn it over to my colleague, Scott Hill. Scott is new to our firm, and we're very excited to have him because he is going to add a capability to our firm that we have not had, and it's about charitable clinics. So, Scott, you're on.
Oh, thank you, Rex. Isn't it horrible that they make us all share one desk here? So, my name is Scott Hill. I'm going to talk to you for a minute about charitable trusts. And specifically, probably the most common type of charitable trust is a charitable remainder trust. Well, you might say, do I qualify for a charitable trust? I'm not wealthy enough. Well, the only qualification for setting up a charitable trust is if you don't like paying taxes. A charitable remainder trust can be set up with cash, it can be set up with money in a bank account. However, most charitable trusts are set up with appreciated assets, either real estate or stocks, mutual funds, other securities that have gone up significantly in value. And the reason for that is when you set up a charitable trust, it's a tax planning tool as well as an estate planning tool. When you set up that charitable remainder trust and fund it, the assets that you fund that trust with, appreciated real estate, you avoid paying the capital gains taxes. In addition, you'll get a second tax benefit. You get a large tax deduction that you can carry over for several years to offset other income of yours. So I'll give you a one example because to me, these particular clients checked off all of the boxes on when a charitable remainder trust might be useful. I had some clients years ago that he was in his late 60s. He was getting ready to retire from a longtime job at Chrysler. Well, back in the 1980s, he had built a rental apartment building, had 6 units, not a huge building, but as you can imagine, building it in the 1980s, it had gone up over 40 plus years significantly in value. And he wanted to get out from under the hassle, particularly he was retiring. He and his wife wanted to travel. And as you can imagine, an apartment building, not only are you dealing with the hassle that comes along with tenants every once in a while, but the maintenance costs were skyrocketing and he was having to deal with that. Taxes had gone up. It was a hassle that he wanted to get out from under, wanted to just travel with his wife. The biggest reason that he had not sold that property is it would basically all be capital gains tax. And so he wanted to avoid that huge tax bill, which he could have done and then had much less to try to invest. But he also didn't want, if something were to happen to him, his wife to have the hassle with the tenants and with trying to deal with that. But in addition, they had 2 adult daughters that had not made good life choices. They had both been married multiple times, bankruptcies. He knew and had a lot of creditors. he and his wife knew that they would have no retirement for themselves. But he also knew if they left them with a lump sum that it would be gone. I saw a study years ago that estimated that over 87% of estates that are left to beneficiaries in a lump sum are completely gone between 14 and 16 months. And my experience over the years has been that that's pretty accurate. So he set up a charitable remainder trust. They transferred this apartment building into the charitable trust. He got a large tax deduction that he can use for several years to offset his other retirement income. The property was sold, no capital gains tax, so the entire amount went into the trust. And the trust has a 6% payout rate. So not only is he out from under the hassle of dealing with that, but it's paying income, 6% return on the assets and paying that out. If something happens to him, his wife will continue to receive that income, and that income from that trust will be received until both of them have passed away. But then, and this is where the remainder word kicks in, when something happens to the second one of them to pass away, they have left the income stream that they were receiving in that trust to their daughters for 20 years. You can go to a maximum remainder period of 20 years. So not only have they got out from under a huge tax bill, got a nice deduction that they can converted a hassle into an income stream, but then also by the time both of them pass away, their daughters will probably be nearing retirement age, and they have provided some retirement income that they probably wouldn't have otherwise for them. And at the end of that 20-year period, when whatever is left in that charitable trust will be paid to their local church and some other charities that were important to them that they set up. So in exchange for that gift to charity that will be decades down the road, they received the tax benefits up front when they needed them and could use them. But in addition, also provided some good estate planning for their family. It also has been used to provide elder law planning because it's an irrevocable trust as opposed to these revocable living trusts that Rex has talked about for estate planning. It's an irrevocable trust, so that specific asset is now out of their estate. So that's one tool. The charitable remainder trust is often used for tax and estate planning.
Okay. Marty, we can now take questions, but I see people talking in the chat about the Q&A being grayed out, and for us, that tab doesn't exist at all. So we have no idea what questions people will have to us.
There's two of them in here so far. There's one that's from Anonymous. If we set up a separate Texas trust for firearms, but the beneficiary lives in Illinois, what happens when the trusters die? How would the trust protect the asset in this case?
That is a good question. I believe that the way it works, assuming that it's been set up correctly, and the ATF typically approves it, the assets are in there, that is going to continue to protect those firearms. However, I am not an expert on that. And with more specific information, I could find one of my colleagues who deals with that issue more than I do. Obviously, Illinois is one of those states that is not a fan of firearms, but I think it's a federal issue, but I'm not 100% sure.
Okay. Jean asked, I'm just curious, why is being a doctor a high-risk occupation?
Well, first of all, depending on the kind of medicine they practice, uh, doctors get sued more than most other professions. Um, but not all doctors. Some doctors are in, they're more likely to be sued. Um, but the second thing is there's a perception that doctors have money. And I worked my way through law school working for personal injury firms. And when I made the comment a while ago about people, their retirement plan is winning the lawsuit lottery, I'm not kidding. There are people who would come into our offices and they had been involved in what would appear to us to be a minor fender bender, but suddenly uh, they find out, oh, he's a doctor, he's got money. Yeah, come to think of it, my neck does hurt, my back does hurt. And we would weed those people out by sending them to our own doctors and verifying the injuries. But there's a lot of personal injury firms out there that don't do that. Um, so the perception of money, and another thing, and I had a doctor tell me this one time, he got sued for malpractice. It turned out that he hadn't done anything wrong, but it became relatively public knowledge. And I'll never forget him telling me, uh, it really hits home when somebody tells your kid on the school playground, your daddy hurt somebody. Um, and doctors can be an easy target for that. I'm not saying all of them will be, but it certainly can happen.
Okay. The Gay asked, my brother's only asset is his house. Is it important to have a trust for it for the house? His only income is Social Security and a small pension.
Um, well, the question is going to be what's going to happen when he dies. Um, you're going to pass it in some shape, form, or fashion. If it goes through probate, then anybody who thinks they have a claim against him can bring it. If you do something like a transfer on death deed or a ladybird deed, you seem to avoid probate, but you don't necessarily know that it's going to wind up where he would like for it to go. So, yeah, trust even makes sense in a case like that, though most people in that situation aren't going to do it because they feel like the cost of preparing a trust, it's cheaper to do a will, but they're never going to see the cost of probate and what probate does to their family. But
I'm sorry, Rex, and I'm just throwing this in, what about the Medicaid recovery as it relates to trusts?
so that normally Medicaid recovery, they're not going to be able to go after assets that are in the right kind of trust. Medicaid planning, there are Medicaid trusts out there that will protect those assets from Medicaid recovery. We don't do that kind of work anymore. We can refer somebody to someone who does that kind of work, and they would be able to opine on that. I will tell you this. When we had somebody in our office who was doing it, I was amazed at some of the people who were able to qualify for Medicaid that I wouldn't have thought would be able to qualify for Medicaid.
And I only bring that up, Gay, is if your brother were to need a nursing home care for a short or long period of time, is there you want to be able to protect the house from the Medicaid coming back and putting a lien on the house for the cost of the care. There's ways to do that, right? Is that correct?
Yes, and particularly if it goes through probate, Medicaid recovery is one of the statutory things that they can use probate for.
So the trust does not go through probate, so that would help protect that. Yes.
That helps, and if they really need to qualify for Medicaid, Medicaid planning, like I say, we refer them to somebody who's good at that. And like,
yeah, one other thing about that is if they do end up in needing care, long-term care, and they qualify for Medicaid, the thing is you don't want to sell the house, because once you sell the house, you turn it into cash, and the house and a car are the things that are exempt. Is that right, Rex?
yes,
And once you turn those into, once you sell them and turn it into cash, then it becomes it's no longer exempt, and then all of a sudden they have to go, they end up off Medicaid until they've spent all that money down, and then they have to go reapply.
that's exactly right. Medicaid planning, in my mind, is pretty tricky, simply because of the kinds of clients that I've had coming in over the years. I don't see a lot of Medicaid clients. I've never developed the expertise on it, but we maintain relationships with people who do a lot of Medicaid and are good at it.
Yeah, and I'm just trying to make the point of just because it's a house, and the situation may end up being a Medicaid issue, that they want to protect from. So
That's exactly right.
What is an AB trust for couples that was mentioned earlier?
That's a great question. Glad you asked. Here's what happens with an AB trust. When one spouse dies, the assets are divided into two sides, an A side and a B side. The A side is the surviving spouse's share, and A actually stands for the above ground spouse. And yes, B actually stands for the below ground spouse. Now, the surviving spouse is typically the beneficiary of both sides. But when the surviving spouse dies, what was in the B share goes to where the first decedent said it would go. And one question that I have asked clients over 32 and a half years, and the answer I'm sure is going to shock everyone. I'll ask them, if you died first, do you want your assets to go to your kids, or if your spouse gets remarried, to your replacement? And I've never heard replacement. And the other thing is, people think, oh, we're never getting remarried. Well, until you've been there, you don't know that. I've had a lot of surprises with clients. I could tell stories for a while about that, but the possibility of remarriage, it's easy to ignore it, but it's not necessarily safe to. The other thing that the B share does, while the surviving spouse is alive, we design the B shares in such a way that the assets in it are protected from lawsuits. So if the surviving spouse were in a car accident, they couldn't take from the B side. And then we tend to put on the A side assets that are protected by their nature, like homestead, life insurance, annuities, qualified retirement plans, things like that. So there's a lot to AB planning. And the other thing that the B share does is it keeps the assets in the B share out of the taxable estate of the survivor. Whether the B share is subject to estate tax is determined at the first spouse's death. And then it doesn't matter what it grows to. It's not subject to estate tax again. So
Very interesting. Very interesting. I won't forget the AB trust, what it stands for. That's
yeah,
great. Yeah.
I was very surprised when somebody told me that. I thought it was a joke and I looked it up and no, it's real.
Wow.
I thought it was
Yeah.
just the first two letters of the alphabet, but
Yeah.
no.
Someone worked hard to come up with that. Rachel asked that my parents have a living trust, but the only thing in there is their house. Do they need to include their retirement accounts, 401k, pensions, IRAs, as well as any insurance?
Um, if you include retirement plan assets, if you move those to the trust, that is an immediately taxable event, and you don't want to do that. You can name the trust as a beneficiary. However, that is not simple planning, and a lot of living trusts are not drafted in such a way that they make good beneficiaries for that. The way that we try to do it, if they'll do the Heritage Trust, we can have the trust be the beneficiary of that retirement plan. And sometimes for the surviving spouse, we'll use the trust, but normally they're going to do a rollover. But you've got to ask, are we talking about first marriage or second marriage? Retirement planning is tricky. And I mentioned the retirement plan trust. It's a great tool that works for a lot of situations. But you have to really evaluate what are they trying to accomplish. Are they going to do rollovers? That's generally the easiest thing to do for the couple, but it doesn't necessarily work if you've got, if it's a second marriage, maybe they've married late in life and one of them already had a large IRA, or maybe both of them did. Well, a rollover may not be as practical because, for example, if the husband dies first, but his intent is for that retirement plan to go to his kids, he can't let his wife do a rollover on that. But if he does a rollover on it, he allows a rollover and she rolls it over, it's hers. She can give it to whom she wants. And I've seen that kind of planning go haywire where the surviving spouse had a great relationship, and I can think of a couple of situations where this has come up. Had a great relationship with his kids, but then we hear from them. Wow, used to hear from them on Christmas, and they would be here, some years for Christmas, and we'd see them for Easter and Thanksgiving. Now I don't hear from those kids at all. That relationship, the husband was the glue that held that relationship together. And suddenly she sees those kids differently. They're not my kids, but this is my money. I'm not giving it except to my kids. So there's a lot of issues involved with that.
Very good. Anonymous says, can you complete a transfer on death deed at your mortgage company or bank without having to hire an estate planning attorney?
I don't know. In theory, a title company could do a transfer on death deed. But do keep in mind that that transfer on death is one of those first four ways of passing assets that it could wind up going to somebody you never intended to see benefit. And a good example of that, you pass it down to a child, for example, and you think, I want it to go to my kids. Well, we had a case one time where the kid died 10 days after mom. It was passed by TOD. Where does it go now? Well, he was in a second marriage. He had minor children from prior to the marriage. They didn't get anything. Is that really what mom and dad wanted? Probably not. So I'm not a fan of using TODs and ladybird deeds because I've seen too many things go wrong. It's again, there's 22 ways you can lose control of assets like that.
One of the things that I need to add is the Texas State Legal Center, I believe that's the correct name. I know they assist with transfer on death deeds. I don't know if they assist with ladybird deeds, but they may assist with that as well. But there are some. There's also the Legal Aid of Northwest Texas. That's a income qualifying. The Texas State Legal Center, I believe, is anybody can qualify for. But I'll have the contact information for those in the follow-up email, just in case you're looking for that. So I'm going to go on. Thank you. It's very helpful. Okay, very good. Thank you for your response, Gary. Okay, I'm 53 years old, single, and no children. Live in Texas. I own my home and have no debt and financially secured. Upon my death, I plan to divide my assets between charitable organizations and multiple nieces and nephews, two of which live in Asia and are not U.S. citizens. What's the best trust what that you would recommend?
That's the kind of case that a revocable living trust works very well for. And giving it to charity, I'll let Scott address part of this if he has something else to say about it. Normally, in a case like that, you're not necessarily trying to create income. You're just making a flat out gift to charity. And it doesn't take anything fancy to do that. But Scott, is that a situation where something like a charitable remainder trust would be beneficial?
It could be, depending on what his goal was. Now, is it something that it really kind of depends on the underlying asset. If he's planning on, for instance, if it's his home as described, and he's planning on continuing to live in the home, you would probably just want to use a revocable living trust. You can't fund a charitable trust with the home you're still living in. So as Rex said, a revocable living trust would work really well with that. If they're just outright distributions to charities and to nieces and nephews, we usually recommend you use percentages in that case rather than flat amounts, because you don't know, what will be left. But revocable living trust would work well.
Yeah. Okay.
Very good.
That's why we share a desk, so we can agree on things.
There you go. I sent you both links so you could be in different offices in case you disagreed. But I guess they didn't provide that for you yet, Scott, huh?
We did. We thought it'd be easier to be in here because he was going to be looking at the screen. But anyway,
it's all right. We know you were just wanting to make sure that whatever he said you agreed with, right, Rex?
right. Absolutely.
What is Anonymous asked? What is the cost range for a simple trust? In other words, own a spouse with no children. I guess only a spouse and no children, I believe is what they're trying to say, maybe.
I could give you fee ranges for a single person to do a trust with us with all the documents that we include with it. starts at $4,000, and then the options they select with that trust, it can go up. For a married couple, it starts at 4,500, and depending on the options, can go up. We've had a few here recently, and we really like these cases where they're, you know, $15,000 for all the things that people are doing. But trusts are kind of all over the board. They're not all the same. And Marty, can I share a story about a client I had years ago?
Yeah, go ahead.
I had a couple come to me. They had been to some guy's seminar. They met with him and they thought he was too expensive. Their financial advisor told them, "Hey, Rex is a young lawyer. He would probably do a good job for you, and he would probably charge you less." Well, they came in, and in fact, I quoted him a fee that was more than twice what the other attorney quoted, but they hired us. And the guy did complain about our fees, but the reason he hired us is because we answered all his questions. Well, they came in and signed their documents 2 weeks later. About 3 weeks after that, we got a call, and they called to apologize for complaining about our fees. They had gone to that workshop with their next door neighbor or best friends or somebody close to them. And those people met with the attorney, hired him, and then they met with that attorney, and then they looked us up, hired us. We had their documents done in 2 weeks. And when their neighbors got their trust back, it had taken about 6 weeks. They decided we're going to sit down and see and compare them. And they called us and said, and by the way, our next door neighbors think they got ripped off by the other lawyer. He was a lot cheaper, but he did not do nearly as much. And that was, trusts are a lot like houses. Some of them are tar paper shacks. Some of them are mansions. The important thing is that you get a plan that does what you need it to do and go in with open eyes about what you really need. Because just because somebody can do a trust for way less than we can doesn't mean it's going to do what you want to do.
So, but what you're looking for in someone to do it is, and obviously you want to do your due diligence on who you're looking at, but you're looking for a estate planning attorney. Is that correct, Rex?
Yes, you want to get somebody who does this a lot. I mean, they might be able to do some other things, but when I look at attorney websites and they do practically everything under the sun, we see some of their estate plans and they're not very good at all. You want somebody who does this because we keep up with the rules, we keep up with things that are going on. We develop new strategies. We're not pulling it out of the form book that you can buy right out of law school that seemingly will let you do everything if you just fill in the blanks right. We customize, and the good firms out there are like us. They're going to customize and make sure that the plan does what you need it to do.
Yeah, before we get to the next one, I'm just going to add, Lori in the chat said that she didn't know if Hogue Barnett participated in such programs, but her legal benefit at work covered the entire cost of setting up her trust. And she says, I think the benefit was through MetLife, but it was through her work. I know, some companies now have legal assistance as part of their benefit packages. So,
and we work with some of those programs, and there's several of them out there. Normally what we do is we'll quote our fee, and then that company will pay whatever that company pays, and the client will pay the difference. Some of them do cover the entire cost. It just depends. I also get these invitations, hey, you can get $100 for doing a will for somebody. And I'm like, no, not even gonna touch it. Uh, that's not profitable work for anybody unless they just have a form they're filling in 10 minutes and having you come in and sign. Uh, but there's some good programs out there. There's some are better than others, but we'll work with them.
The next one, anonymous asked, please explain what happens when the beneficiary lives out of the country.
Hmm. Okay. Well, it is legal to transfer assets to somebody who is out of the country if you're a U.S. citizen. You're then going to get into the issue of what are the laws in that other jurisdiction. And I can't always tell you that. One of the questions we had this come up with a client recently. Husband and wife were from two different countries, and then they came here, and they were both from civil law countries. Well, I could tell them what happens in a common law country, but not in a civil law country. And they're just two different systems. America is generally on the common law system. And civil law, there's some features of civil law here in America. Community property is a civil law concept, but it depends on the other jurisdiction.
Okay. Anonymous asks, I'm divorced and have an 8 and 10-year-old children, but I'm getting remarried in April. Should I put a living trust in place before I get married or wait?
I'm tempted to answer yes. It does make sense to have it before you get married, but here's the biggest thing that I see married couples do. They ought to sit down and do this kind of planning before they get married, because there's things that start happening the moment you get married that we don't get to talk to them before they get married. They come in and they've got a major mess. They both had assets from prior to the marriage. They had kids from prior to the marriage. They've put stuff in a joint bank account. They commingled some assets that were separate property. And sometimes, and it's not, by the way, the concepts of separate and community affect tax law. They affect inheritance law. They affect debtor-creditor law. And, clients who come in and say, well, we're never going to get divorced. We don't need to worry about that. Yes, you do. Because if you do the wrong thing with the IRS, I tell people, unless you look good in a gray jumpsuit and like the weather in Fort Leavenworth, you don't want to mess that up and have the IRS accuse you of tax fraud. So the ideal thing, get a plan in place and then update it right after you get married.
Okay.
It's a great question, by the way.
I have a trust. How can I tell if it's a heritage trust?
It's probably going to be hard for the average person to look and see. Though I will tell you this, if it gives it outright to your kids, you don't have it. If it's not put in a protective trust, that prevents the assets from being taken by creditors and predators and divorcing spouses, then you don't have the heritage trust.
Okay.
We, by the way, do review others' plans and could answer that at no cost for somebody who comes in and visits with us.
Okay. If I have a client that only has a house and money in the bank, no POA, and is currently working on a will. Spouse passed away 5 years ago and has three children they want to pass on their the assets to. It sounds like a trust is the better option instead of the will, right? Um, and could your could you reiterate the cost of setting up a trust?
Um, at least in our office for a single person, it starts at $4,000. It includes, um, I've not really counted them, 12 to 14 other documents. Um, and then there's options that you may put in. There's extra costs if you do the Heritage Trust. And normally that's going to be the issues, but in at least based on that, no retirement assets. But generally, all I can really kind of do is tell you in cases like that, fees range from roughly 4,000 to about 11,000, depending on the options you select. But you do get a good plan for $4,000.
Um, um, and the other part of the question was, it, you, your advice would be to look at a trust and not a will, right?
Yes, trusts just do so many more things. We have a handout that if somebody would email us and ask for, we can show you 53 things you can do with a trust that a trust will do better than any other estate planning tool out there. And not everybody needs all 53 of those things, but there's an impressive number of things you can do with a trust that you can't do with other tools.
Okay. Anonymous asked, does a common law spouse in Texas have rights to claim any assets?
Yes. Basically, if you have truly a common law marriage, then it's treated like you're married. You have the same claims that um, somebody with a marriage certificate would have. Um, Now, it might be tricky to prove that up sometimes, um, but it can also be shockingly easy sometimes. Um, and by the way, you're when you go in and you start doing planning for that, um, people don't realize this, but it's more complicated to do planning when somebody is common law married. Um, there's just more issues you have to consider, and you typically have to be more careful about uh, assets as far as where they're going to wind up. Um, I had a couple one time that after we talked to them, they decided to go get married. And I thought this was quite funny. We designed the plan before they got married. The day they scheduled to sign, um, they said they had just gotten married at the JP's office. And as they were leaving, they said, we're now on the way to see our lawyer. So they had a great sense of humor. But we thought it was neat that they came by and signed their documents before they went on their honeymoon. That's how everybody who's in that situation should do it. Kind of kidding, of course, but
Yeah. Yeah. I have a buddy that his parents got divorced. His dad ended up with the house they grew up in, and this was in California. And that it was supposed to they both had kids, his new wife and him, and the house ultimately was supposed to be split up equally between all of their kids. And it wasn't a few weeks after he died that she went and changed it to go exclusively to her kids and cut his kids out altogether. So yeah, it's,
That happens.
yeah,
I've seen that more than once and it's sad.
yeah,
And I hear it from, you know, people will come in and they'll be complaining about what happened. You know, dad died and she wound up with everything and um, they're ticked off about it, but there isn't anything we can do. Um, yeah, that's one thing the AB prevents. Um, so, but yeah, that's sad, and I think those kids they don't really get over it. And it
yeah,
also they may have become friends with, let's say, the spouse's kids, but something like that even kind of blows up those friendships.
yeah, yeah. And all of those dynamics are going on. You're absolutely right. That whole everything you just said is all going on in that, and it's been a few years now, and it's still the dynamics um, are going on. Let me ask Margaret. Asked you talked about property deed, um, but recently we had an estate with mineral rights and several states and counties in those counties in those states. Texas was easiest, but Oklahoma required filing a probate there. Can that be resolved with a trust?
Yes, and mineral interests are kind of tricky in Texas. Um, each county has their own rules about what they require, and each mineral company has their own rules about what they require. And we had a case where this couple had a piece of property that was spread over 3 counties, and they had 3 different mineral companies. We ended up with 9 deeds. It was complicated. Um, but we transferred them into the trust so that that could be passed easily in the future. And once that's done, you don't have the same tricky issues. So yes, for example, if it's Oklahoma, we've got colleagues in Oklahoma that we'll turn to help us do the mineral interests up there, and they can be done slightly different in other states as well. So mineral interests get real tricky, and some people don't want to do it because they think, oh, we're only making, $500 a year, and it could be that it's going to cost $1,500 to get the interest transferred. I get it, but uh, it'll be lost entirely if they go through probate, or the probate will be a lot more difficult than a Texas probate. Um, so definitely it can be fixed with a trust, and it's a good idea to do it. Um, wish we could talk every single client who has that situation into doing it.
Rex, can we advance a slide? It's that time. I want to repeat the information about CEUs, and then there's 3 more questions. If you like, if you have time, Rex, can we come back real quick and address the 3 that are left?
Sure.
Okay, so for those of you that are joining us for CEUs today, we're providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas or a license outside of Texas, you're more than welcome to go through the process and get a certificate and submit it to your jurisdiction. But please note, there's no guarantee that they will take them. I've had different professions in Texas and people outside of Texas tell me they've been able to use them. I've additionally been approached by jurisdictions for more information on webinars we've done, so they can determine whether the material met their standards for their CEUs. So all I can say is if you have a license or you have license outside, go through the process, get their certificate, and then but just know there's no guarantees. We're also doing certificates of attendance are available to anybody who's been on for the whole time. That the rules apply the same for a CEU as they do for a certificate of attendance. Today's webinar was worth 1.5 hours of CEU credits. You must complete the entire live webinar until right now, which is 11:30, and that's the advertised time. We realize you have other commitments and things on your calendar, but you also don't forget you also must complete the Google evaluation survey, or you do not qualify for any certificate. The Google evaluation survey should pop up as you close out of Zoom today. It actually is Zoom inviting you to take a short survey. If you click on that, that will take you to our Google evaluation survey. The survey link will also be sent out in the follow-up email tomorrow. The survey will be live until the 28th, and then and that's the deadline. And please give us at least 4 to 5 weeks to those certificates will be emailed out to you. They come out by email. So if you give us that time, we're even farther behind than that right now, but hopefully we're going to get caught up. We are making ground. So to go back to Rex, the anonymous says, I have a trust from a few years ago. Would the cost of having it updated be the same as doing a whole new package? She adds that, or he adds that they now have grandchildren.
That may depend on the firm you go to. The way we do it, when our clients come in to update, it isn't nearly as expensive as starting all over. And we even give a break if one of our wealth counsel colleagues, let's say their client has moved from another state, we give them a break, even though for us it's a brand new project, but that way we're helping our wealth counsel colleagues and ultimately helping our clients. So it depends, but sometimes we will also give credit if we can look and see that the trust is well done. It might not be ours, it might not be on our system, but we do sometimes give some credit for it because we're stupid, I guess. We haven't come up with a good reason for doing it, but we do sometimes do that.
Okay. Anonymous asks, I'm a widow who owns a home in Houston. My only sister lives in New Orleans, Louisiana. Our mother died in New Orleans, leaving us a house and a rental property, both of them in New Orleans. What type of attorney and which state should assist us, and what type of trust should we get? I have 2 daughters who reside in Texas and South Carolina.
Okay. Well, first of all, as far as transferring the Louisiana property, you're going to need a Louisiana attorney to do that, or at least someone licensed in Louisiana. If it's actually requiring a Louisiana probate, you're going to need a Louisiana licensed attorney to do that. As far as if the person lives in Texas, a Texas trust can be created by a Texas attorney. Having kids in both Texas and South Carolina, I kind of touched on some of the issues you have when kids are from out of state. So those are things that you can ask your Texas attorney about as you do that plan.
Very good, very good. There's still, we're back to 3 again. Rex, you tell me when you need to to stop, but do you want me to keep going?
Sure.
Okay. Lori asked, I have a trust, revocable trust that only involves assets in Texas, but a successor who is also a beneficiary is in another state. Does my attorney need to record the trust in that state, in the other state, to avoid probate?
No, what's important though is that if there is property in the other state, that it be transferred to the trust. One nice thing about a trust, you can have your Texas trust can own, property in any other state, and it'll avoid probate in those other states. Well, the one exception to that is Florida. For whatever reason, and I hope this will change, Florida even has trusts go through probate. I can only conclude that their probate bar has a great lobby there, but generally, if you've got property in another state, what we do is we'll help you find an attorney in that state who could transfer that property into the Texas trust. That's the key thing. Make sure that the assets are all owned in that Texas trust.
And that's true with everything, right? I mean, even the stuff you have in Texas, whether it's bank accounts or whatever, the problem is once you set up the trust, it doesn't do any good unless you move everything into the trust, right?
That's kind of a myth because of the pour over will. The trust does still do things for you, even if it's unfunded, but it works a whole lot better if you do get the assets transferred in, because that's what it takes to avoid probate. But at least with the pour over will, we pay the assets to the trust. So there's other benefits of the trust that, it's a shame that you have to go through probate, but there's still other benefits, the asset protection for the kids and that kind of thing. You can still get even if you have to go through probate.
Anonymous, this is a good question. When you set up a trust, or when the trust is set up, who would make sure that the executor does what they're supposed to do?
Well, okay, that's kind of trusts don't have executors; they have trustees. Executors execute the terms of a will. Trustees manage the trust assets. There are some common things between those two roles, but generally, trusts, a trustee owes the beneficiaries a fiduciary duty. They're responsible for carrying out the terms of the trust. If they don't, they can be held personally liable. And I'm going to say that there are occasionally cases where trustees, just like anybody else, you've got some bad trustees out there. But the most difficult thing, what do you do if an executor steals the assets in an estate? You've got legal recourse, but it's not fun. You've got legal recourse with a trust, but it's not fun. But one of the things that we do when we deal with trust administration, we emphasize you're personally liable for what you do. You're personally liable for the way you do it. You're liable for the way that you protect information. And you've got to carry out the terms of the trust. And I tell people, hey, this is kind of like being in the Marines. Thou hast not to like it. Thou just has to do it.
Okay. They keep coming. We're going to do two more, and then we're going to, because I've got to get ready. I've got another webinar set up here that I've got to get the information out on.
Okay.
Can you live with someone for a few decades as significant others, girlfriend, boyfriend, and we never be considered common law as long as they don't refer to themselves as married? Would this help the trust situation?
Um, well, the answer to the first part is yes, if there's no claim that they're married, um, then yeah, they're not married, they're just living together. Does it help a trust situation? Um, well, I think having a trust helps anybody, but honestly, there's a lot of problems with simply living together and not getting married from an estate planning standpoint. It can be very tricky, particularly if they own a house together. Um, it depends on, if they don't have any joint assets, that's a little bit easier, but if they've been living together for a number of years and it's his house and he dies, suddenly she might be out of a house because she doesn't get the homestead protection. So lots of things to think about.
Okay, the last one. Should you share your trust with everyone affected, I guess, by him, or only the trustee?
That's a great question. It depends on the situation. Um, if you just using the example, you've got three kids, they're all going to be equal beneficiaries. They get along well. You can go ahead and share the information if you think it makes sense. From time to time, um, the kids either don't get along, or you've got reasons that you need to keep something from, one of them. Maybe it's not because they don't get along, but that's a very much an individual family decision. Here's the thing that I tell people though. There are no pleasant surprises in estate planning. And if you are going to do something that is unusual, I would recommend that you talk to the kids about it beforehand. Um, you don't want your kids going to war with each other. If you love them, you want them to, try to get along. Don't make your poor estate plan the reason your family broke up. And that kind of happened in my wife's family. Very sad, poor planning, dispute between my wife's two siblings erupted, and it's sad. And I would have never imagined that from their family. But sadly, that's not uncommon. But I think it's better if you do share, unless there's real specific reasons that you shouldn't.
I'm living this first hand as we speak. I've spent 3.5 out of the last 5 months in California dealing with my mom's house. I'm the only boy. I have 3 sisters, 2 older sisters, and my parents had asked me years ago to be to be the trustee or the administrator of the trust. And this trust was set up. My mom says she shared it with all of the siblings. Well, she suddenly ended up in a nursing home very unexpectedly about 6 months ago, and she's there permanently. And so they found out when it came to her house that I was the trustee, and they will not speak to me. They haven't spoken to me in 6 months. They're absolutely furious. They've refused to help my mother with any of her medical needs, which they were doing before, or her banking needs, or anything. They've just literally dumped it, taken it to the nursing home. One of them took the banking stuff to the nursing home and made my mom sign that she'd given her all the banking stuff, all of my mom's banking stuff. It's just a nightmare. And and I had no idea that they didn't already know that, and so I got caught in the middle of it. And like I said, they haven't spoken to me in 6 months, and we'll see what happens. But yes, I sure wish my mom had shared the information before now, because it just made it much more difficult in dealing with it. So that, but like you say, it's an individual deal. Rex, thank you so much. Scott, thank you so much. It's incredibly nice to meet you. Um, do you have anything you want to say before either of you before we close out?
Scott, you got anything?
No, thank you, Marty, for the opportunity. I hope it helped in some way. So thank you.
Did I call you something besides Scott? What did I call
No.
you? Okay, I just want to make sure I had it right. Sorry.
Yeah, you got it right.
Okay, good.
Um,
Okay.
Just as usual, always glad to share with people on these webinars, and look forward to working with you again in the future.
Sounds great. Yeah, I hope you've been able to see in the chat all of the appreciation that's been pouring out in the
Seen several
chat.
nice comments.
Really nice comments.
Yeah, we appreciate that.
You all, thank you so very much. Look for the follow-up email. Someone asked, is there a recording? Yes, there's a recording. It will be about a week, and then we'll have it up on our YouTube channel, but we are recording it. So thank you all for joining us, and look out for the follow-up email, and y'all have a wonderful day. Take care.
Okay, thank you.